Bonjour tout le monde. Good morning, everyone. My name is Ruby Sahota, and I'm the Secretary of State for Combating Crime and the Member of Parliament for Brampton North Caledon. And it's my pleasure to be here with you today. I'd like to start by acknowledging that Ottawa is built on the unceded Algonquin Anishinaabe territory. The peoples of the Algonquin Anishinaabe Nation have lived on this territory for millennia. Their culture and presence have nurtured and continue to nurture this land. Today, the Honourable Gary Anandasangaree, Minister of Public Safety, along with the Honourable Sean Fraser, Minister of Justice and Attorney General of Canada, joined by Eric Stubbs, Chief of Ottawa Police Service, will speak to the introduction of Bill C-22, which was introduced in Parliament earlier today. This bill will support law enforcement agencies and the Canada Security Intelligence Agency, CSIS, with the tools that they need and have been asking Parliament for to investigate serious threats, disrupt and dismantle organized crime, and protect our communities. I'd like to now introduce our other guests, who are standing right behind me here at the podium, joining us here today, and we're very grateful for all of the support that we're receiving on the introduction of this new bill. Commissioner Thomas Carrique of the Ontario Provincial Police and President of the Canadian Association of Chiefs of Police. Senior Deputy Commissioner Bryan Larkin of the RCMP. Deputy Chief Nick Milojevic of Peel Regional Police. Police Chief Myron Demkew from Toronto Police Service. We also have Michael Gendron from the Canadian Police Association, and I'd also like to acknowledge my colleague present here today, MP Seema Akan. To give you an idea of how today's event will unfold, I'll invite Chief Stubbs to say a few words off the top to set the frame for how law enforcement sees the need for lawful access. After that, Minister Anandasangaree will deliver remarks, followed by Minister Fraser, after which we'll have a brief Q&A session. With that now, I'd like to invite Chief Stubbs to say a few words.
Thank you. Bonjour. Good afternoon, everybody. And Ministers, thank you very much for the opportunity to say a few words. And of course, my fellow policing colleagues that are here today, thank you for coming up to Ottawa. The policing community is very pleased with the government's intentions to modernize the laws as it pertains to lawful access. The reality is that crime has changed faster than the laws and processes that police rely on to investigate it. La criminalité évolue plus vite que la loi et la façon dont la police enquête. As I represent a municipal policing service, I can tell you that our detectives are required to secure production orders for an overwhelming majority of their investigation. It can involve phones, apps, online accounts, messaging, platforms, or cloud storage that may be operated by multi-companies and a multi-jurisdictional area. Even when judicial authorizations is available, the process can be slow and it can be complicated. And in some cases, by the time critical information is obtained, valuable information is lost. I want to give you an example that occurred a few months ago here with the Ottawa Police Service. A female victim had AI-generated deep-fake intimate images of her posted online by an offender who used 6 separate social media accounts. On November 13th, 2025, we submitted production orders to all of the companies related to the 6 social media accounts. The return of the data varied from 12 days to a full 11 weeks. Then the team transitioned to tracking down the 5 IP sites that the offender was using. This shows the complexity of the data trail that detectives have to follow to resolve this and many other files. One production order leads to another one, leads to another one. So the sooner that this legislation that ensures there is a consistent and binding return date from the companies, the quicker our teams can prevent further victimization. Simply, when timely access to data is delayed, so is our ability to protect victims. Sans accès rapide aux données, il est plus difficile de protéger les victimes. I gave you one example that we encountered a few months ago. There are many others related to child exploitation, human trafficking, organized crime, and fraud files where time and access is crucial. To be clear, this is not about asking for unchecked powers, and it is not about setting aside rights. Ce n'est surtout pas en question d'ignorer la protection des citoyens. It's about ensuring that when police have the legal grounds and the judicial authorizations to obtain information, the system works in a way that reflects the speed and complexity of modern crime. Police look forward to working with government, parliamentarians, privacy experts, industry partners, and communities to ensure that the framework is effective, balanced, and worthy of the confidence of Canadians. Le service de police est prêt à collaborer pour enquêter de façon efficace et rapide pour protéger les Canadiens dans le respect de la loi. Thank you. Merci beaucoup.
Okay. I wanted to also mention we have the Parliamentary Secretary here for Public Safety as well, and we've got Deputy Director of CSIS, Nicole Giles. Pardon me for that omission earlier. And next, I'd like to invite Minister Anandasangaree to the microphone.
Thank you, Ruby, and good afternoon, everyone. Ruby introduced her guest off the top, but I want to acknowledge them as well. Chief Stubbs, Commissioner Carrique, Chief Demkew, Senior Deputy Commissioner Larkin, Deputy Commissioner Milanovic, Deputy Director Giles, as well as Michael Gendron from the CPA. I want to just thank you and acknowledge the work that you've been doing for many, many years. I am truly grateful for your leadership on this particular issue, and also grateful for the many conversations we've had to get us here today. Your presence says a lot about how important the legislation we're talking about today is for public safety in Canada. Chief Stubbs did a pretty good job of explaining why we are here. The illustration that he had can be replicated by every police chief in this country. Nos lois n'ont pas évolué au même rythme que les criminels qui les infringent. And when it comes to the laws that govern how law enforcement and CSIS gather evidence and information, Canada is woefully behind our most important allies. Technology has moved forward. Our laws are stuck in another century. Les criminels les savent et les profitent. They use many of the same digital tools that are in our pockets or on our desks, but they use them for money laundering, online sexual abuse, extortion, fraud, and human trafficking. And the criminals are organized, often across borders and continents. Their crime is transnational. The tools we have to fight them are inadequate, and the task at hand. C'est pourquoi aujourd'hui est une journée si importante pour la sécurité publique au Canada. This morning, our government introduced Bill C-22. C-22 creates the legal framework for lawful access regime in Canada, something that law enforcement, security services, and organizations supporting victims have been asking for decades. This new bill has its roots in former Bill C-2, but it is not the same. This new bill is informed by views of stakeholders and parliamentarians who voice serious concerns with the former bill. And I want to thank the Honourable Murray Rankin, who's with us today, for his work in bringing together different stakeholders, law enforcement, victims groups, academics, and civil society, to build a form of consensus on the next step forward on lawful access. Much of this bill is informed by his work, and I also noticed that Leah West is here. Professor Leah West is also here, and I want to thank them for their leadership. Importantly, we listened to what they had to say. And this new legislation, Bill C-22, balances the needs of law enforcement with the privacy and civil rights that Canadians demand. And I want to be clear what C-22 is not. It is not about surveillance of Canadians going on about their daily lives. It is about keeping Canadians safe in the online space. It requires electronic service providers to establish and maintain lawful access capabilities. It ensures that law enforcement can obtain timely, lawfully authorized communications or information when they need it, and only from electronic service providers. Il vise à créer un cadre juridique cohérent et clair pour les fournisseurs de services pour leur permettre de respecter l'ordre juridique existant. So this is a package of targeted reforms that tackle the world as it is, not as it was. We're not looking for sneaky ways to surveil Canadians. We're doing our part to combat bad actors in both the physical and digital worlds. Je tiens à encourager mes collègues parlementaires à appuyer l'adoption rapide du projet de loi C-22. I want to encourage my parliamentary colleagues, and I've had many conversations with colleagues from all sides of the aisle, for the swift passage of Bill C-22. With that, I would like to turn over to my colleague and friend, the Honourable Sean Fraser, and I want to thank him and his team for the incredible work that he's been doing, and particularly the collaboration we've had together on the introduction of Bill C-22. Thank you.
Bonjour tout le monde, c'est un plaisir d'être ici pour partager les perspectives du gouvernement sur le nouveau projet de loi pour assurer que nous avons l'habilité pour protéger nos communautés. Juste avant de commencer, je veux remercier mes collègues à la colline du Parlement, but in particular, I want to thank the folks you see standing behind us with different law enforcement agencies across the country. Your work, not just on this bill, but to help inform the legislative agenda of the government when it comes to public safety, is so sincerely appreciated. And let me echo the gratitude that Minister Anandasangaree expressed for Professor West and our former colleague in Parliament, Marie. It's wonderful to see you here today. To the two of you, this has been a tremendous act of public service that's going to help make Canada safer, and we value your input through the process sincerely. I think it's helpful to put this bill into the broader context of the new government's approach to public safety in Canada. The strategy that we've adopted rests on three key pillars. The first is to adopt stronger criminal laws to ensure that we have the ability to deter crime in this country, to punish wrongdoers and communicate to communities that we take public safety seriously as an issue. The second is to ensure we make investments in the front line. Yes, this includes 1,000 new RCMP officers, 1,000 new CBSA officers. It also includes support for community organizations that are on the front line of the justice system, and it includes ensuring that our law enforcement agencies have the tools that they need to investigate, to prosecute, and most importantly, to prevent crime in the first place. The third pillar is making upstream investments in things like affordable housing, mental health and addictions, and programs for at-risk youth to build healthier people and healthier communities so we have less crime and less violent crime in the long term. But today we're talking about that second pillar. En particulier aujourd'hui, engager le deuxième point. Pour assurer, nous avons des politiques pour soutenir des policiers pour des investigations et pour prévenir la violence partout notre pays. It's important to understand that crime has evolved. over the last number of decades, not just in this country but around the world. And our laws have not necessarily kept pace with the strategies used by criminals and criminal organizations. Most of us will appreciate how much the world has changed when it comes to the technologies that we use and how it feels like the world is shrinking when we're increasingly connected. Well, that principle and perspective applies equally to criminals and to criminal organizations. We need to ensure that Canada's laws, like many of our allies around the world, evolve to address these modern threats. That's where this particular bill comes into place. By establishing a regime of lawful access, we're going to better equip police forces to investigate and to prevent human trafficking, smuggling, extortion, and a number of other very, very serious crimes that demand the full attention of the government. If you think about this in practical terms, and Chief Stubbs, I think, did an excellent job of sharing how this plays out in reality, you can imagine the difficulty for someone investigating a crime when they have information about what kind of activity may be taking place that's tied to a phone number or an IP address, but have no knowledge of the person who may be behind that information. It's perhaps obvious to say, but you can't arrest a phone number or an IP address. There are real people who are committing crimes and hiding behind the anonymity that comes with modern technology. By ensuring that we have a process where first we can establish which service provider actually holds the IP address or number that may be used that demands a criminal investigation, we can actually better understand who we need to work with to get to the bottom of these investigations. And of course, once we understand which network we may be dealing with, we would have the ability where we believe there is reasonable suspicion that a crime has been committed to actually have a court say that you can get identifying information about the person we suspect is tied to these crimes. These processes are designed to protect people's privacy rights, but ensure that we have the modern tools that are necessary to address crimes that are taking place in the modern world. This is going to help us catch up with most of our allies around the world, but most importantly, it's going to help the officers on the front line do more to help keep communities safe in every region of this country. Merci tout le monde, c'est un grand plaisir d'être ici avec vous. Et juste une autre fois, un grand merci pour nos partenaires pour être ici aujourd'hui et pour les perspectives quand nous développons ce projet de loi. Merci tout le monde.
Thank you very much, Minister. All right. Sorry, Secretary. So we'll take your questions. One question, one follow-up. Une question, un suivi. Please specify your name, outlet, and to whom you wish to ask your question. S'il vous plaît, spécifiez votre nom, le média pour lequel vous travaillez et à qui vous adressez votre question. Merci.
Good afternoon, Ashley Burke, CBC News. Minister Fraser, what did the government compromise on or drop entirely that was in the original bill? That's in this bill compared to the original bill C2 after there was a backlash over privacy concerns?
Certainly, and look, one thing, although you've sort of framed it as backlash, I actually find that the perspectives that come out when you first table a bill in Parliament engage a conversation that allows you to improve the laws that we've adopted. Some of that perspective came from opposition parties in the House of Commons. Others came from experts in their field, whether it's law enforcement, privacy experts, those who are very well versed in matters of national security. The kinds of things that we heard was that there was potentially overbreadth with the first version of the law that went forward, particularly when it comes to what the definition of service provider would include. By restricting the definition of service provider to electronic service providers, effectively cell phone companies, internet service providers, we can communicate to Canadians that our intent is not to go after healthcare information from a family physician, for example, but instead are trying to track down the manner in which criminal organizations and criminals are using modern tech to commit crimes. Though a question was put to me, I should give full credit where it's due. Minister Anandasangaree has been doing a lot of the heavy lifting on this file, and I'm sure, Gary, if you wanted to supplement the answer, you can do more.
And after the shooting at Tumbler Ridge, what materially does this change on that front? Why doesn't this bill compel social media and AI companies operating outside of the country to hand over information that Canadian law authorities are requesting?
The work on this bill started well before Tumbler Ridge, and enormous amount of consultation has led towards this version of lawful access that, as Minister Fraser says, balances the interest of law enforcement, of concerns of civil liberties groups, academics as well as tech service providers. There was definitely a need, as you know, if you speak to anyone in the child protection space, for example, they will tell you that a lot of work and a lot of work involves social media platforms. Some of them which are located outside of Canada, and there was a need to ensure that Canadian law enforcement have access and a mechanism to obtain the information that is so critically important, so that lives could actually be saved. And in the case of, I think, the example that Chief Stubbs provided, it could have saved his investigation days, if not weeks, before he was able to get the required information. So I would say it's a matter of great importance for law enforcement and to essentially to ensure the safety and security of all Canadians.
I'm Jillian Piper with Global News. Minister Anandasangaree, I'd like to ask you a question. The new bill would allow the Public Safety Minister to deliver ministerial orders urging telecoms to hand over Canadians' data. Why does your government believe a minister should have the power to make that request instead of leaving it to law enforcement?
Well, to be very clear, the primary responsibility is with law enforcement going through obtaining judicial authorization. So there's different mechanisms in order to obtain the data. The first piece is really confirmation of service. So for example, you have a phone number, you call, law enforcement will be able to engage with the provider of cell phone services and say, is this phone attached to your network? And if the answer is yes, then they would commence production orders that can start at the first stage on getting basic subscriber information, which is on a reasonable grounds to suspect, and then go further, again, through judicial authorization, get additional information relating to reasonable grounds, based on reasonable grounds to suspect standard, be able to get additional information as required.
Thank you. And what guardrails does your government have in place for the protection of Canadians' data once you receive it?
There are a number of very important protections that are in place, built in to this legislation. The first and most important piece is the narrowing of the scope of what service provider means. So it is limited to electronic service providers. Secondly, there's a specific exclusion for medical information and protection of legal information or legal counsel privilege that is available to individuals. So if there's solicitor-client privilege, then that is specifically excluded from this bill, and no attempts can be made to obtain that data. There is a 3-year review period wherein this entire legislation will be reviewed by parliamentarians, and there is also a component where the Information Commissioner will be tasked to advise on measures that the Minister of Public Safety will be taking.
Hi, I'm Catherine with the Canadian Press. Is there anything in the bill that would allow internet or phone companies to refuse to answer a confirmation of service demand? And I also noticed the bill doesn't include any new powers for Canada Post to search mail. Are those now off the legislative table?
So the second question, the provision, the Canada Post provisions of Bill C2 remains in Bill C2, and that is not part of this particular bill. This is strictly focused on lawful access, the ability of law enforcement to, in order for them to get basic information and a regime that will enable them to, through judicial authorization, get additional information through the court process. So it is very much a targeted, very narrow type of bill that doesn't go into other areas that are critically important, but not included in this bill.
Thank you. And I'd also like to ask, will the government support the bill from the Conservatives that would create stand your ground laws?
Sorry, can you repeat that, please?
Will the government support the bill from the Conservatives that would create new stand your ground laws? Their news release says the bill would make changes to the criminal code so that force is presumed to be justified if used against an illegal intruder.
Sure. Look, this bill having just been put forward, I've not had the opportunity to read the text of it, but the issue does come up periodically. So first, I think the most important thing to understand is that in Canada, you have the right to use reasonable force to defend yourself and others who are in your home, should you be facing a circumstance where someone may intrude and threaten violence. It's essential that we maintain that rule, which has been put in place several governments ago, and we support the rule as it exists. The second consideration is something that I hope people will reflect on seriously. There are jurisdictions who have adopted the kinds of laws that you've just described, sometimes with fatal consequences. We have seen in places like Texas and Missouri fairly recently horrific scenarios. In one instance where a young boy who was playing Nicky Nicky Nine Door was shot by someone behind a closed door and ended the life of a young boy. There are others who've shown up to pick up their siblings at the wrong house by mistake and suffered a similar fate. We have to ensure that as we adopt rules that promote public safety, we don't incentivize behaviors that will endanger the lives of innocent people who may mistakenly show up on someone's doorstep. The path forward will require continued engagement, but when it comes to the ability to defend yourself in your home, Canadians should know that they have that right, and that right will be protected under this government.
Mari Wolf from the Globe and Mail. There were concerns expressed when Bill C2 was introduced that lawful access could actually produce vulnerabilities in our systems and make...
Sorry, the microphone's just tipped up. It's difficult to hear. Yeah, thank you.
Yeah, shall I start again? Sorry, Mari Wolf from the Globe and Mail. There were concerns expressed that lawful access could actually introduce vulnerabilities in tech systems and make them more vulnerable to hacking and also actually to bad actors in hostile regimes. I'd be very interested to know if any safeguards have been introduced in this version of the bill, and not only from the Minister but potentially from CSIS as well.
Answer that first. Go ahead. If you, and then
but it's part 15.
Sure. Okay. So look, we've consulted with companies, service providers, technology companies on their concerns. The issues around vulnerabilities within like information that is held by different entities is a concern across the board. Cyber attacks are happening, and they are definitely happening in numbers that we haven't seen before. However, lawful access regime does in no way contribute to greater threats for cyber attacks. In fact, the tech companies are required to have protections in place to ensure that information and privacy is contained and it is secure. And any breach of that, there are mechanisms to address that, including informing individuals of the breach. But the regime that we have and we're proposing in no way contributes to any furthering or vulnerabilities that may be found within our tech systems. Look, overall, information technology and the enormous amount of information that is available online are secure for the most part. If there are attacks that create vulnerabilities, it is the onus of companies to be able to secure that data, and we expect companies to be able to do that in a way that protects all Canadians. Do you want to add that?
The issue of cybersecurity is one that is very critical to CSIS and also to our colleagues who work next door to us in the Cybersecurity Center. And there's quite a bit of information that the CCCS provides to companies in terms of how to ensure that they're protecting themselves against vulnerabilities, and we work very closely with our partners on that. The provisions of the Privacy Act continue to apply at all times to CSIS's activities, and we work very closely with the Privacy Commissioner, with the independent INSERA review body to ensure that we're following all those rules and restrictions and that we're very careful with the data of Canadians that we are privileged to receive.
In other jurisdictions, the introduction of a backdoor effectively has made them more vulnerable to cyber attack, and there have been incidences of this, as I'm sure you know. And the current Bill C-12 actually introduced a prohibition on sharing information on vulnerabilities, which experts in the field said was a mistake, because that is a key way of patching up problems by saying we've identified a hack and telling colleagues in the industry that this is something that needs to be rectified. Can you tell me if that clause in the original bill is still there, or if you've changed it?
The bill, many aspects of what was in Bill C-2 continues in this bill, and in this particular provision that you reference does continue on. There was a tech briefing, if I recall. I don't know if you had a chance to listen to it, and you know, we would be able to provide additional clarity by our experts as well if you so require.
Rachel Aiello, CTV News. My first question is for the RCMP. It's my understanding that the new bill won't allow police to search digital content, just subscriber information. Can you clarify for Canadians what tangible investigative advantage that gives the police that they don't already have?
So thank you very much. Thank you very much for the question, and certainly open it up to my colleagues from policing across the country as well. You know, obviously we provided a significant amount of collaboration, so all police services have been engaged with Public Safety Canada, with the Honourable Murray Rankin. We recognize that there's a fine balance here of public safety versus Canadian privacy. And as police leaders, our focus is on victim-centric solving crimes. And we now have there's a proposal to have a lawful access regime. And that is actually one of the essences and the strength of Bill C-22, is that we actually now have a regime, where previously there was no regime. It was built on relationships with electronic service providers. There was a collaboration of 24 police services across the country that came together to work with telcos, to work with, obviously, social media companies, et cetera. And so this actually brings a framework. It brings strength to us accessing. It also, when you look at the confirmation demand, it answers significant challenges that our Canadian courts have outlined for police services. And so the example I'll use is that, 25 years ago, 30 years ago, every investigative room in this country had a phone book. And in that phone book, detectives and investigators would go through and look at addresses, names, and phone numbers. The world has changed. And the home address now is an IP address, and the phone number is some mobile phone, a burner phone, another piece. And so the modernization for us to access that information through confirmation of service, which then allows us through a special production warrant, which is actually less intrusive than an overall production warrant. And so that is the essence of where we're at. And so we believe that this does give us modernized tools. It gives us the ability to actually do investigations. But I'd be happy to have one of my colleagues, Commissioner Carrique and or Deputy Chief Demke or Deputy Milovich, to bring you a perspective from a municipal perspective, because our interest also from this is from a national security perspective, from border integrity investigations, from our federal mandate, which we think will drive some significant work that we do, but also it's important to hear from the municipal and or provincial lens.
Thank you, Senior Commissioner. I think the best way to answer this question is to just really place it very simply. The reality is that lawful access currently is as important as forensics is. Forensics over the course of decades has continued to evolve. The legislation around lawful access has not. In actuality, the last significant change to it occurred prior to the iPhone being developed. And our ability to access information lawfully with the barriers, and not the barriers, but the guardrails to protect people's privacy interests are crucial to almost every significant crime that we investigate. And I would use the example of Peel. For example, we're dealing with extortions right now. It begins with a threat that's delivered digitally. And our ability to identify the people that are responsible for that and do it in a way that is expedient is absolutely centered on our ability to access information lawfully, judicially, and with the guardrails that protect people's privacy interests. But that legislation hasn't evolved to the point where it should. so that we can do that. So really excited about this announcement and the enhancements to the legislation, and I do believe it is going to carry genuine value and benefit, not just in extortions, but really any crime where a person is using different devices and there's digital evidence of that crime, which is virtually the majority of the complex crimes we investigate right now.
Thank you. My follow-up question is for the Minister, Public Safety Minister. If this legislation is so crucial that current major criminal investigations are essentially being hindered without it, do you take accountability for overreaching the first time and relying or resulting in this delayed second attempt?
So let me just say Bill C-2, the original version of it was, has been in the House since June. We have, as we expedited Bill C-12, which is now the Borders Bill, going through the various processes, including the Senate. We have been working towards consensus or near consensus, because I don't think you can have full consensus on this, bringing the different stakeholders, different parties together towards building and having a framework that is acceptable to, I would say, the majority of those who are part of this conversation. So I would say from the outset, we started the consultation. I spoke to virtually every single law enforcement personnel leaders here. I've spoken to dozens of police chiefs across Canada and police associations. Minister Fraser and Secretary Sahota have been doing the same thing. And we wanted to make sure that we get this right. And I do believe that we have the right balance. And we're moving forward on the introduction, which happened today. But more importantly, we're looking forward for this to go through the different stages and hopefully be passed expeditiously by all parties. I look at this as a nonpartisan bill, one that Canadians need, one that law enforcement has been asking for many years, with the requisite safeguards I think we've been hearing from individuals that are required. My outreach to the different parties leads me to believe that this is an area where we can have some cooperation and be able to pass this at the earliest possible juncture.
Good afternoon. I'm Natalie Van Roy with CTV News Ottawa. My first question is for the Senior Deputy Commissioner of the RCMP, Bryan Larkin, please. How would this bill ensure that social media giants like Instagram and Facebook would comply with this proposed new legislation and hand over the IP addresses associated with the alleged criminal behavior?
Well, thank you for the question, and nice to see you, an old Waterloo Region colleague. Natalie, it actually sets out the lawful, as we've heard from Deputy Milinovich and from Chief Stubbs, is it actually sets out a lawful access regime. And so right now our partnerships and our ability, obviously our criminal code has a significant abilities for policing already to search out information, to collect data. But one of the things that I want to highlight is the critical part of this proposed bill is timely access to data. And it sets out a significant regime around electronic service providers to comply with judicial orders, with timeframes, as well as addressing the financial impacts and implications, as well as also having the capability and the capacity to provide the digital data to policing. It's outlined in the federal proposed federal legislation, which will allow us to expedite. Right now, much of the work, police leaders and a shout out to all of our frontline investigators, they're very resourceful. And right now they're relying on relationships, they're relying on a good partnership, using judicial authorization to get the information they require. But you heard about that from Deputy Milinovich, you heard about it from Chief Stubbs. This is also about expediting and ensuring that those who are victims of crime actually receive the necessary service, the necessary care, and the immediate urgent attention from police services that they duly deserve. And right now, there is nothing in there that allows us to manage it. You heard it from Chief Stubbs, 11 days to 11 weeks. And when we're dealing with urgent critical information, the proposed legislation lays out that framework. And we do believe that will bring some significant ability for us, not only domestically, but also internationally, dealing with our allies and our partners, because they often also require, they have lawful access regimes, we have mutual, lawful enforcement processes that we do with them. This will help us actually also expedite relationships with international and allied partners.
Thank you. And my follow-up question is for Chief Eric Stubbs with the Ottawa Police Service. In terms of the bill, the proposed bill, how would that cover public computers in libraries, shared devices, and shared Wi-Fi, where law enforcement may gain access to the IP addresses but not have the specific individual's identity?
Yeah, thank you for the question. You know, investigators deal with that still, where there's a nondescript location or a public forum. They have ways, obviously, to manage that. A location is certainly important, and there's other ways, whether it's CCTV of who's actually at the computer. They usually will leave other digital footprints that investigators can pursue, but everything is a little bit individual and specific to every file in every case.
Thank you.
Thanks.
Hi, my name is Dale Smith.
Sorry, sir, if I can just add to Chief Stubbs' comments. Some of the key and critical components of this proposed legislation allow us to advance our investigations where previously there was no pathway forward. So the thresholds that have been built into the legislation as we understand it, the confirmation of service, reasonable suspicion to allow for a production order, then to progress through various forms of judicial authorization will allow us to get the key components required to identify offenders and also identify locations that will allow us to advance criminal investigations that are just simply stopping at unacceptable points. There has never been a more important time in the history of this country for this legislation. I engaged in the first conversation on lawful access in 1996 when police leaders said we were at risk of going dark for access to digital evidence. We are now here 30 years later with the support of this government. This is a nonpartisan issue. This is a public safety issue. From internet child exploitation to extortions to home invasions to carjackings to drive-by shootings to hate-motivated crime to extremism, lawful access is absolutely required, and it's required now. So on behalf of the Canadian Association of Chiefs of Police, my thanks to this government and my hope that all parliamentarians will work together to ensure the safety and security of this country. Thank you for your time.
Dale Smith, I'm with National Magazine. First question's for Mr. Fraser. The Supreme Court of Canada has twice ruled that lawful access is unconstitutional. What makes you so confident that this time you'll get it right?
The previous rulings of the Supreme Court of Canada didn't rule out the constitutionality of lawful access in all circumstances and in all forms, but certainly versions that have made their way through Parliament on previous occasions have received that treatment by the court. One of the things that give me a high degree of confidence that this legislation is not just needed but constitutionally compliant is the process of engagement with experts who know what they're talking about, not just from a law enforcement point of view, but also from a privacy rights point of view, also from a constitutional point of view. Again, pointing to the work that Murray Rankin and Professor West have engaged in to bring their expertise and the voices of others who understand how you can both protect the security interests of the nation and respect the privacy interests of citizens at the same time, was really what a lot of the bulk of that exercise that took place between the initial introduction of C2 and now the introduction of this bill. And that exercise with very specific recommendations on what could have changed as between the two versions of the lawful access regime that's being put forward give me confidence that we're going to be able to, in a minimally impairing way, ensure that law enforcement has the information they need to complete investigations and to prosecute and prevent crime.
Second question, whoever wants to answer it. Essentially, what my understanding is that the technical requirements in this bill will force telecom companies to ensure that phones will have real-time tracking information. And I'm just wondering, that sounds ripe for abuse, and what kind of safeguards you can, reasonably give Canadians.
Thank you. Look, it requires telecommunication companies, for example, to provide in an accessible way data that is required and demanded upon provisions of a production order. So it is built in as a requirement. With respect to location, it is essentially based on what the service provider is already doing. So there's no additional requirement for them to provide that except in circumstances where, in a very narrow set of guidelines, may be required. So it is not on every particular demand, but it is on at times where it may be required for the immediate safety and security needs of an individual who, for example, may be humanly trafficked. And whose life may be in danger. So it is under very strict circumstances that would be allowed.
Thank you.
So this will be the last question and follow-up. Dernière question est suivie. Merci.
Good afternoon. Christopher Nardi from the National Post. The first question to Minister Anandasangaree. Can you tell me what lessons have you learned since the failure of C2 and the first version of this reform, and have you secured opposition support for C22 already?
No, Parliament is a learning experience, and I've learned a great deal in the last 11 years. And one thing I've learned is that at times when more work needs to be done on a particular bill, you retreat and you come back. You come back with better consensus, better consultation, better supports from across the board. C2 was introduced within the first days of our government, and it had a number of very important provisions, every one of them important both from a border security perspective. Issues around postal, for example, is to ensure that, for example, fentanyl does not go into remote communities via postal, which is something that is very prevalent, and we know that. I was in Yellowknife last week, and it's a concern that was highlighted to me by members in Yellowknife, by communities in Yellowknife. So it is very much part of, I think, this journey of C2, where C12, many provisions are now going through the final stages of the Senate. C2 without postal is being introduced. Lawful access is being introduced, or was introduced this morning, and we hope to, at a later date, ensure that the issues around postal are addressed, because it is critically important. At the end of the day, as our government ensures that we provide additional tools to law enforcement, which is what Minister Fraser talked about, his second pillar, that lawful access is a central tool that every single law enforcement agency, every single police association that I have spoken to have demanded. This is in line with our Five Eyes G7 partners, and I was at both of those meetings, and we are an outlier in this, and we're very much catching up to what I think are many missed years of not having a lawful access regime.
Sorry, and on opposition party support? Sorry, it's the second part?
Sure, yeah. Opposition, I've been speaking to opposition. As you're aware, we're not able to provide a copy of the draft legislation until the legislation is tabled. We did that today, and I look forward to having more conversations with a number of colleagues on all sides of the aisle. But as is, the initial sense I have is that there will be some support, and we certainly look forward to the swift passage of this bill, and we will ensure that we are in constant discussions with all the parties to look at a path moving this forward.
And the next question is actually for Mr. Larkin and Ms. Giles. The Part 1 of this bill is significantly reduced in scope. It went from all service providers to only telcos. Now, I know that both police and CSIS have talked about that unwarranted kind of client information portion as being important to be able to respond quickly before asking for production order. Are you happy now with how circumscribed that power has become, or is it now going to become a hamper for you?
Hi, Chris. Thanks for the question. I think it's an important one. The provisions in Bill C2 are going to give CSIS significant advantage in terms of providing us with the building blocks of investigations for us to be able to go to a telecommunications service provider, ask them the simple yes-no question in terms of whether a service has been provided to an individual that we have reasonable reason to suspect is potentially involved in a national security threat. That will give us and our investigators significant advantage in terms of providing us with that building block information that will then allow us to move beyond that requirement of minimally intrusive to seek a warrant to be able to get the additional information. And where that will be incredibly valuable for us is, for example, if we have an investigation where we have a phone number and we know that there is a potential extremist attack that's being planned or plotted associated with that, there could be 20 telecommunication providers nationally, and we don't know which one to ask in terms of whether that service has been provided. And by being able to use the provisions in this bill to ask those simple yes-no questions, that will allow us to get much faster to the situation where we can ask for a warrant to be able to get more specific information. So we're very pleased.
Thank you, and I just want to build on Commissioner Carrique's comments, and I want to highlight that the strength of Canadian policing is right here, where you have the National Police Service, a Provincial Police Service, and Municipal Police Services together in lockstep. Every single day we're sharing criminal intelligence, we're sharing information, we're sharing investigative work, and we collaborate. And so around the work and the policy recommendations and the policy discussions that the current government has proposed on C-22 is a voice of Canadian police leaders, as Commissioner Carrique alluded to. We recognize that the, particularly Article 14, and as Director General Giles, Deputy Director Giles alluded to, Article 15, confirmation of service demand, as Commissioner Carrique alluded to, those are tools that we currently don't have. And investigations are either stymied, roadblock, or put on a desk, come back around when we get more information. So there's an actual series of tools here that will eventually lead to greater success, greater efficiencies in police investigations, greater solvency in crime, and quite frankly, improving the safety of Canadians, but more importantly, addressing the concerns of victims, because that's our mission, is to support those that are victimized. And so I think, again, there's a parameter in the proposed bill of a three-year renewal. Commissioner Carrique talked about 1996. Technology has evolved significantly, policing's evolved significantly, but we've lagged around the actual legislative reform, the legislative piece that allows us to access a modernized digital world. And so the particular proposed legislation brings us years ahead, and from a policing perspective, we see this, and the RCMP sees this as a significant step forward, which gives us tools that we currently don't have. And from a policing perspective, on behalf of my colleagues and Commissioner Carrique and Chief DEMQ, Chief Stubbs, and Deputy Milinovich, there's not a day that's gone by that we've not talked about policy, legislative reform related to the proposed legislation. So thank you.
All right, I wanted to invite up Chief DEMQ to say a few comments, if you'd like. I know that we haven't had an opportunity to hear from you.
Well, listen, I appreciate the opportunity to just say a few words and echo what you heard from both the parliamentarians and police leaders. This is about public safety. It is about community safety. It is about the ability of the policing community to respond to victims of crime under some of the most difficult and horrendous of circumstances. One needs to only think about child exploitation, human trafficking, shootings, extortions. Behind these headlines are people, are victims, and the ability of the community to come together and support victims is essential. and importantly, the ability of the policing community to be able to advance investigations in a timely way and to speak for those who cannot speak is absolutely critical, and that is fundamentally what this legislation is about. And we truly welcome the opportunity to have advancements in lawful access in this meaningful way. And as you heard, this has been a conversation virtually my entire policing career. And we are now catching up to our Five Eyes partners in a meaningful way, and it is quite frankly long overdue and very, very welcome in the policing sector, and most importantly, will continue to provide us an ability to respond to the difficulties we face in our communities across this country and speak for victims and bring the most difficult of circumstances to closure, with offenders being put before the justice system to be held accountable for their acts. Thank you.
Thank you very much, Chief Denku. Merci tout le monde. Thank you, everyone. This concludes today's press conference. Thank you.
Merci tout le monde. Great job.